he was on a recorded jail line speaking to third parties, asking them to pass Miss Key, Miss Bobby Key, the victim, messages and money in an attempt to, as he stated, put her in good humor so she doesn't pursue these charges.
All right, I've been handed a document indicating that in docket number 14949, he will be pleading no contest to count 1 aggravated assault, receive a sentence of 5 years. Tennessee Department of Corrections suspended to supervised probation with credit for time served, $200 fine and costs. He's to have no contact with the victim, Bobby Key. Restitution will be determined, but he must also complete anger management classes. As a condition of his probation will be 0 tolerance for any failed drug screens while he's on probation. Counts 2 and 3 are dismissed. Count 4, coercion of a witness, a plea of no contest. He'll receive a sentence of 3 years. Tennessee Department of Corrections suspended to supervised probation. Concurrent with count 1, credit for time served, costs, no contact with the victim, must pass all drug screens while on probation. Mr. Jones, raise your right hand. Let's place you under oath.
You solemnly swear or affirm that the testimony shall now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, we're going to be recording this, so I need you to speak up loudly into that microphone, okay?
Yes, sir. I don't hear well.
I understand that, but I'm going to try to speak loudly, so if you'll speak loudly back at me, okay? If we get to shouting at each other, that's okay. State your full name for the record.
David Wayne Jones, Sr.
Mr. Jones, you're here today charged with a number of offenses. I've gone over what the agreement is, but do you understand what you're charged with? And if you and Mr. Bradley have an opportunity to go over the charges, discuss the evidence against you and any possible defenses you might have?
I understand.
Do you understand that you have a right to plead no contest to this case? And what that means is you're not saying you did anything wrong, but you're not going to deny it. Then the state's going to tell me what their evidence would be if this case went to trial, and I'm going to use that to support a finding of guilt. Do you understand that?
I understand.
Do you understand, however, that you have a right to plead not guilty and have a speedy and public trial by jury in this court?
I understand.
Do you understand that at trial you would have the right to have a lawyer, to have one appointed for you if you could not afford your own?
I understand.
Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything? Do you understand that?
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
I understand.
Do you understand that if you went to trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir. I understand.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
I understand.
You understand that by pleading no contest, you are waiving or giving up your right to a trial and to an appeal. And all I'm going to do is approve what your lawyer has worked out with the state.
Yes, sir. I understand.
You understand that's going to result in 2 convictions, and those convictions are both felonies, and they will be on your record in the future to make more severe the punishment you'll receive if you are ever again convicted of a crime.
I understand.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest and give up your right to a trial according to this agreement?
Yes, I understand.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
You understand I can't accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty of these charges.
Yes, sir.
Then I want you to listen as the state tells me what their evidence will be if this case went to trial.
Yes, Your Honor. If this case-
I tell you, maybe hand that microphone to General McLeod. Let her have her opportunity to speak into that microphone and tell us what the evidence would be.
Thank you, Judge. If this case had gone to trial, the state would expect to show that it relates to count 1, the charge of aggravated assault. On April 28th of 2024, the Houston County Police Department made contact, or to say the city of Erie and Houston County Police Department made contact with Miss Bobby Key, who told officers that her boyfriend had hit her in the face with a walking stick. The impact of the walking stick hitting her face had ripped off part of her lip, shattered her jaw, and knocked several teeth out. She had to have treatment at the hospital, surgery, things of that nature. While Mr. Jones was in jail, as relating to count 4, the coercion of a witness, he was on recorded jail line speaking to third parties, asking them to pass Miss Key, Miss Bobby Key, the victim, messages and money in attempt to, as he stated, put her in good humor so she doesn't pursue these charges. There are multiple messages, conversations of that nature between Mr. Jones and multiple third parties while he was incarcerated. That's the basis for the 2 counts that he is pleading guilty to.
All right, Mr. Jones, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
I understand.
You still wish to enter a plea of no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Bradley has done a good job of representing you competently?
Yes, sir.
Mr. Bradley, do you know of any reason you should not enter this plea?
No, Your Honor.
Anything further from the state?
No, Your Honor, that the restitution needs to be determined at a later date, so the state would ask for a restitution hearing.
All right. Then David Wayne Jones, upon your plea of no contest in docket number 14949 to the charge of aggravated assault, a Class C felony, I find you guilty, sentence you to 5 years in the Tennessee Department of Corrections that will be suspended to supervised probation. You'll be given credit for time served, a $200 fine and costs. You're to have no contact whatsoever with the victim, Bobby Key. You're ordered to pay restitution, but that restitution will be determined at a sentencing hearing on February the 11th of 2025. You must complete an anger management class as a condition of your probation. There is to be 0 tolerance for any failed drug screens while you're on probation. That means 1 failed drug screen will send you to prison for 5 years. Counts 2 and 3 are dismissed as a part of this agreement. On count 4, you're found guilty of coercion of a witness, sentenced to 3 years in the Tennessee Department of Correction, suspended to supervised probation, and that will serve concurrently with count 1 for a total sentence of 5 years probation. You're ordered to pay the court costs and again have no contact with the victim, Bobby Key, and again must pass all drug screens while you're on probation. You need to see the probation department before you leave. Thank you.
Thank you.